comments? Justice Alito?
It would help me to get clarification of your position on a couple of issues. I took from your brief and from your answers at an earlier point in the argument that whenever there are multiple IQ scores, they must be assessed holistically in light of all relevant evidence, and by relevant evidence, the relevant evidence would include evidence about adaptive functions. That's how I understood your brief. That's what I understood you to say at an earlier point in the argument. But then you just recently said, if there is a case where there are, let's say, 5 100s and 1 71, the inquiry could be cut off at the point. It would not have to get into any adaptive function. The inquiry could be cut off at that point. Is that correct?
I think, considering the expert testimony, if a court—
Expert testimony about the IQs or about other things?
About the IQ test administration and meaning of the test, a court could say, look, nothing you can offer is going to convince me that in fact his true IQ is 70 or below. That would be measured, that determination would be measured for clear error. In other words, what the court would be saying is, yes, of course, each side is entitled to offer—
Okay, so there could not be a categorical rule. There can never be a categorical rule that IQs plus testimony about the IQs is sufficient, and a court would err if it went beyond that and opened up the possibility of holding that there was not intellectual disability. You said it would be with the court could do it, and that it would be reviewed for clear error.
What I am saying is, if there are multiple, one or more IQ test scores that are within the range of intellectual disability, that is 70 or below, it is error for a court to refuse to consider expert testimony and evidence relating to other psychometric tests and school and prior diagnoses to determine whether the defendant meets his burden to show prong 1.
So in just about every case then, IQs and testimony about IQs can never be sufficient.
I don't know how to— I've given you every possible answer that I have. I think a court looking at whatever it is, 500s and 171, considering the testimony about how those tests were administered and what the reliable results of those tests are, could conclude, look, that's it for me. There's nothing you could show me that would change my mind.
I'm still perplexed also about your view regarding the relevance of Alabama law here. Does it matter what Alabama law says on these points, or are we looking for the minimum Eighth Amendment standard?
What Alabama law says about how this is or isn't proven is the Eighth Amendment commandment of this court in Atkins. That is, it allows states to apply various standards in order to make a determination about the Eighth Amendment violation or not. As we know, the state can apply different levels of burdens consistent with the Due Process Clause. There are some states that say, if somebody is charged with a crime and comes in with a score of 65 even before the trial, he is presumptively ineligible. I mean, there are lots of ways in which states have established rules to enforce, quote, the constitutional mandate we announce.
One final question. How are we to determine what the national consensus is based on state court decisions that are struggling to understand what this court has said in Hall and Moore?
The state has cited one and only one case in which the court has expressed perplexity, and that is not even a state court. It is a federal district court applying the federal death penalty in the Eastern District of New York. You can look at every single one.
Let me just ask it another way, and then I'll give up.
Well,
how are we to determine?
Or I'll
The state courts are trying to apply our decisions. And would you deny the fact that that's what they're doing? They're just going off and deciding what they think is the morally appropriate way of dealing with this question? Or are they trying to understand what this court has said? And if they're trying to understand what this court has said, how can that show a national consensus in the sense in which we've used that term in prior death penalty cases?
the state courts have uniformly looked to Hall versus Florida and this court's announcement of its rule in Hall, its two-part holding in Hall versus Florida, and said to determine substantially sub-average intellectual functioning, we look at all probative evidence, including, of course, the test results from properly administered IQ tests.
All right, thank you. Thank you.
Okay.